Good morning, everyone, and welcome to our session this morning on planning for the future mental capacity. My name is Jessica Steingard, and I'm one of the staff lawyers here at the Center for Public Legal Education Alberta, or CPLEA for short. Our goal is quite simple, and that is to make the law understandable for Albertans. And so that's what we're here this morning to share a little bit on the topic of mental capacity. We are a nonprofit organization. We serve all of Alberta, and we provide legal information in a variety of ways. So we have booklets, tip sheets, videos, websites, webinars, etc. Anything to get the information out there. Okay, we are as I said, today we're talking about mental capacity, planning for the future. This is actually the first in a series of 4 webinars we're hosting over the next about month and a half. So we have a new one every 2 weeks. So watch for the next couple coming up. At the end, I've highlighted the dates just in case you weren't aware of those. So we'll be talking about making a will next time, and then personal directives and powers of attorney. And then we'll be finishing with the Adult Guardianship and Trusteeship Act at the beginning of March. Before we move on, I'd like to acknowledge the traditional homeland of the many diverse First Nations, Métis, and Inuit people whose elders have walked this land before us, and those persons with whom we share this great land today. So I am here in Edmonton in Treaty 6, but we know that there are people joining us from across the province and even beyond. So welcome, everyone. Okay, just a quick disclaimer before we get going this morning. So our presentation this morning contains legal information only, and it is not intended to be legal advice. A few housekeeping things as well. We are recording today's presentation. We will be sharing it as an on-demand webinar on our YouTube channel in about a week. So we'll send out a note to everyone when that becomes available. We also ask that you save your questions till the end. We're going to try and leave about 10 to 15 minutes for audience questions. You're free to use the Q&A chat throughout the presentation, but we will get to all those questions at the end. And please do post them in the Q&A function, not the general chat. And as well, I'd like to acknowledge the generous funding provided by the Alberta Law Foundation and the Department of Justice Canada that make presentations like this one possible. Okay, let's move into today's presentation. So we've got kind of 2 parts today. I'm going to be sharing a little bit about the law around mental capacity. And then you may have noticed a few other boxes on your screen. We actually have two wonderful people here that are here to share about their experiences with mental capacity in their professional realms. And we're going to have a bit of a discussion around mental capacity, why it's important, and some of the different roles different professionals play in this when it comes to this topic. So that's our kind of goal for today. Before we get started though, we just want to do a quick poll just to see kind of who's in the audience and where everyone's at. So we're going to throw up a poll on your screen today. It's going to pop up for you to answer. I'll give everyone a few seconds. Perfect. Okay, so everyone's kind of most people in the somewhat familiar range. That's awesome. And I think we have one more quick question that we'll throw up. Excellent. Okay, so we have lots of people that are excited to learn about CPLEA's resources as well. Perfect. Okay, well, let's get started today then. And I'm going to jump into our first part of our discussion today about mental capacity. So what is mental capacity? Now, I want to just make kind of a caveat here. We're going to use the term mental capacity throughout this presentation, but you'll also hear the term just capacity or decision-making capacity, and they're all referring to the same thing. So what is it that we're actually talking about? Well, it's the ability to understand information that relates to making a decision. And so 2-parter definition here. and the ability to appreciate the reasonably foreseeable consequences of making or not making the decision. So this definition actually comes from the definition of capacity in the Adult Guardianship and Trusteeship Act. And it's really important that we understand kind of both components here, the information as well as the consequences of making or not making a decision. So using that definition, let's just look at a quick example to kind of break down this kind of component here. So our example is Anna is deciding if and where to move to. So fairly general, but decision about moving. So for the first part, Anna needs to understand the information about moving. So some of that information would include the costs of moving. So how much will rent be? Are utilities included? What will they be? Insurance that they might need, moving expenses, etc., as well as information regarding the process for moving. So finding different places to live, signing a lease, the actual logistics of moving everything. All of that information is necessary for Anna to understand in making a decision. Now, the other piece of this is the reasonably foreseeable consequences of that decision. So here we'd more or less be looking at the benefits and disadvantages of moving or not moving. So for example, maybe moving means paying more per month, but it means being closer to work or other amenities or having better access to public transit. Those might be, some of the benefits of moving, as well as a, maybe perceived disadvantage of paying more. But maybe not moving means paying less, which might be a good thing, but also maybe living in a not so safe neighborhood or more difficulty accessing public transit. So these are some of the consequences that Anna would have to think through when deciding whether or not they should move. So hopefully that kind of highlights the two different parts of this decision-making process we're looking at here. When we're talking about mental capacity or decision-making capacity, it's not black or white usually. We're looking at it on a spectrum. So someone may have no mental capacity at all. So they are not able to understand information, not able to, perceive those consequences. So they are considered to have no ability to make decisions for themselves. Someone may have full mental capacity. But then, of course, we've got this huge gray area in the middle where people might have some mental capacity. So perhaps they have capacity to make some sort of decisions for themselves, but not all decisions. So hence the spectrum, because it can range for everyone and everyone's in a different position. That being said, sometimes mental capacity is considered black or white. And that is when we look at signing legal documents. So you can't be in the gray area when it comes to signing legal documents. We are looking for that full capacity to be able to enter into any type of legal agreement. So what can make someone's capacity change? So they move from full to some to no. What can influence their capacity? Well, there's a few things we can look at. Perhaps the most obvious one is a medical condition. So that might be, Alzheimer's or some other sort of progressive condition that's affecting their capacity. Another thing can be stress and anxiety from difficult situations. So that might be losing a family member or someone close to you. That can also affect your capacity. Medication can affect your capacity in terms of it can either make you more clear or less clear. Not taking medication can also have those effects on you. Another one is changing blood sugar or blood pressure levels can affect your capacity, as well as alcohol or drug use, including when you're mixing it with a medication or an illness. So really, there's lots of different things that can affect someone's capacity. And we'll see here, some of these can change your capacity ongoing and permanently, and others can change your capacity, in a time of day or over a few months. For example, if you're dealing with a medical condition, maybe for, 6 months, and then after that, your capacity comes back again. So we're certainly not looking at capacity as something that once it's changed, is permanent. Capacity can also come and go as well. I want to highlight two different types of decisions that we look at when we're looking at someone's decision-making capacity. And we group them into the categories of personal and financial decisions. And this distinction will come up throughout our other conversations or other webinars in the coming weeks, because these types of decisions, we look at legal documents in respect of these different types of decisions. So when we talk about personal decisions, we're talking about things like healthcare decisions. And that could mean from, a very minimal healthcare decision to quite a serious, health procedure or whatnot. We're also talking about living arrangements. So where are you going to live? With whom are you going to live? Your associates, so who, friends, family, who are you going to be associating with? We look at social activities, whether or not you'll be participating in them. We look at your education, as well as your work, so whether or not you'll be working. Education can range also from schooling to just, taking an art class, for example. And then we also consider legal proceedings that are not primarily about financial decisions. Those are also considered personal decisions. Financial, on the other hand, is everything to do with property. So buying, selling, managing, protecting property. And when we mean property, that's literally everything. So that could mean your home, your money in your bank accounts. It can mean investments, belongings, your vehicle, your couch, everything like that. It falls under property. So when we look at decision-making capacity, then, and we've talked about how it can change over time, people can have some capacity to make some decisions, but not to make others. And so when we look at these types of decisions, we can see how someone might have capacity to make some types of personal decisions, maybe about who they're going to associate with or what their social activities will be. But they may not have the capacity to make maybe a decision about selling their home, for example. So we can also see how capacity works in terms of, where someone has capacity to make decisions. And the big kicker here is, why are we having this discussion? Well, no one can make financial or personal decisions for you when you lose mental capacity, unless there's a valid legal document or a court order naming an alternative decision maker. And so that will be the focus of our next few webinars. Will be, what are those valid legal documents, and what are the types of court orders that can be in place that name an alternative decision maker for you. And so this is why we have the conversation of capacity, because it has a real impact on someone, if they lose it and perhaps are not prepared for it, then we have to look at what are the options and who's going to be making decisions for them. So with that, we're going to turn it over to our panel discussion now. So I wanted to just give everyone an overview of the topic. We're going to move into our discussion. We have a few questions to kind of guide our conversation this morning, but I'm going to first take this moment to introduce our panelists. So you'll see their faces pop up on your screens now. So first we have Maya Gordon, who is a partner at Reynolds Mirth Richards Farmer LLP here in Edmonton. She's been working in the area of wills and estates for 10 years now. She is a member of the executive of the Canadian Bar Association Wills, Estates and Trust section, and she also teaches wills and administration at the U of A Faculty of Law. In 2022, she was recognized as a best lawyer in Canada in the area of wills and estates. And she also has a 4-year-old and a 10-month-old. And so she spends all of her spare time and energy chasing them around. So thank you, Maya, for joining us this morning. We also have Melanie Blackwell, who is the Capacity Assessment Policy Analyst and Complaints Officer for the Office of the Public Guardian and Trustee in Alberta. She has worked with vulnerable populations for over 40 years now. The last 17 have been at the Office of the Public Guardian, but she has spent time with both the not-for-profit sector as well as 28 years with the government of Alberta. Ensuring that adult Albertans' rights are recognized is still her main focus of work. And the last 9 years here in Edmonton, she's been working to ensure that decision-making capacity assessment, which we'll be talking a little bit about today, is always focused on the vulnerable adult. She has met and consulted with officials from all over the country, as well as outside of the country, to demonstrate how the Alberta model works here. And she's also working on forming a countrywide committee to look at developing consistency across the provinces when it comes to assessing decision-making capacity. And in her spare time, she spends it on her biggest passion, which is animal rescue. Fostering keeps her very busy and never bored. So thank you, Melanie, for joining us. Melanie has also warned us that we may see cats flying across her screen. So that's something we can all look forward to if that happens. So thank you, Melanie and Maya, for joining us. I see a question in the chat. RMRF is Reynolds Mirth Richards Farmer, which is a law firm here in Edmonton. Okay, so without further ado, let's get into our discussion. I know we've got lots to cover this morning. So let's start with our first question. So what are the roles of a lawyer and the Office of the Public Guardian when it comes to mental capacity? So Maya, I'll get you to start us off on that one.
Sure. Well, thank you so much for having me. As I noted, I teach at the law school, Wills and Estates, so I welcome questions, and if anything comes up, I know there's facilitators, so I'm sure that, but just feel free to ask questions as you need, and hopefully I will be able to answer them. Our 10-month-old did get up at 4:20 this morning, so my mental capacity is a little diminished, I think, because I've been up for a very long time. In terms of the roles of a lawyer, so in our firm, we have a wills and estates group, and our group meets with people who are interested in getting their wills and estate planning documents together. And it sounds like there will be some upcoming seminars on this, but some of the documents that relate to capacity beyond the will are an enduring power of attorney and personal directive. So often when people are coming to our office, they want to complete those 3 documents. As a lawyer in this area, one of the first obligations that we have is to assess whether the person is capable legally of signing those documents. And interestingly, each document has a little bit of a different test for capacity. I can probably talk about that in a future slide, but it's my obligation to meet with somebody and see whether or not I feel that they understand the documents that they're going to sign. And if I conclude that they do, then I will work with them to make sure they get signed correctly. In the case where there's something that we call in the law suspicious circumstances, so that would be if for some reason, your lawyer's spidey senses are tingling that something is not quite right. Maybe the person is signing in a hospital bed and you can sort of tell that they are potentially on some pretty severe pain or other medications. Or maybe a family member comes in with that person and seems to be assisting them to a great degree. Or if there's anything where I feel like potentially capacity might be engaged, my obligations as a lawyer become higher. I sort of need to do a bit more of a determination of their eligibility to sign documents. And so we do not make a capacity determination from a medical perspective. So I can't sign a declaration of incapacity. I can't determine that somebody lacks capacity from a medical perspective. All that I'm authorized to do is to meet with somebody and determine whether I feel that they have the ability to sign the legal documents they'd like to sign. And if I conclude that they do, then I proceed with getting them signed. And just as a quick pitch, I know that many of you watching this probably already work in the areas of mental health or in our hospital system, but it is very important when people are considering doing their wills to get a power of attorney and personal directive alongside the will. We often have to convince clients to do it. I think they think that they'll never lose capacity and they're too young or they'll never need it. And my experience working for people has been that when you don't have them and you lose capacity, which happens not infrequently, as I'm sure Melanie knows as well, it can be very challenging to get guardianship and trusteeship. It can be expensive and complicated. And so that's my pitch to, if you have friends or family who are thinking about getting a will, I always say to get the power of attorney and personal directive as well. And just quickly, in case there are people who don't know, a power of attorney, an enduring power of attorney is a document you can sign. It appoints somebody called an attorney to make financial decisions for you. And a personal directive is a document that you can sign that would appoint somebody called an agent to make personal decisions for you. So if you do those prior to losing capacity, then your family does not have to get guardianship and trusteeship, which can be a much larger undertaking. So that's the roles of a lawyer. I'll turn it over to Melanie.
Morning, and thank you very much, Jessica, for inviting me and the Office of the Public Guardian and Trustee to do these. We always like to be on these webinars when we can. The Office of the Public Guardian and Trustee's role in capacity assessment is much like Maya's, I think, to make sure that people have correct and accurate information. And you're right, lots of people think they don't have to have these documents in place because their spouse will automatically do it or something like that. So our role mainly when it comes to capacity assessment is to make sure that people are aware of the legislation around capacity assessment and that it's quite a tight legislation. There's things you can do and that you can't do, and only certain people can do the assessments. And my role mainly in my job is to provide that education and the training to professionals and to the public, but mostly professionals. I arrange all of the training for capacity assessors and the workshops for physicians and psychologists, and we've actually done a few with lawyers too. I get lots of calls from lawyers asking for information, and we also respond to complaints about private and public guardians and trustees and agents on personal directives, but we cannot respond to power of attorney complaints because our office does not have authority under that act. It's a different act than is what is under our umbrella. So we work under the Adult Guardianship and Trusteeship Act, the Personal Directives Act, and the Mental Health Act.
Perfect. And I'll make a comment, just some follow-up to some of the things that were said. As Maya pointed out, kind of the three legal documents we're always talking about are the will, the enduring power of attorney, and the personal directive, as Melly mentioned as well. And they're so important that's why we're actually doing webinars specifically on those topics to explain more about them, because they are so important to have in place, and especially from the perspective of, they're not just for older people, which can sometimes be the perception. So we will be talking about this a lot more in detail in the second and third webinar. So thanks for that introduction, Maya, as to why we're talking about this and why it's so important. And Melanie has mentioned capacity assessors. We're going to get into them a little bit in one of our further discussion questions, but Maya and Melanie kind of hinted at two different pieces of the capacity assessment process. So Maya's looking at it from a perspective of when someone's signing legal documents, and as she said, she cannot look at it from a medical perspective, but there is sometimes when you need a declaration of capacity from a medical professional, or what we call capacity assessor, and that's where Melanie, that's where your work comes in, correct? That's what most of your time is spent. So we will get into capacity assessors a little bit more, but just to emphasize that distinction on who's assessing capacity and when. Any follow-up to that, Maya or Melanie, or is that no? Okay, perfect. So hopefully that makes it clear kind of the different roles of different people here when it comes to mental capacity. We'll move on to question 2. So why is learning about mental capacity so important? We've touched on this a little bit, but if there's anything you want to emphasize, I'll start with you, Melanie, if there's more you want to emphasize here on that.
I think we talked a little bit about this, like you said. I think one of the comments Maya made was really important, that the ability to write a personal directive is different than the ability to create a will or a power of attorney. Creating the documents is different than not having the capacity to make personal decisions on those. So learning about mental capacity is really important because there's so many assumptions made about people's capacity and when they lose capacity, and the feeling that as soon as they write a personal directive, it's in effect and the agent takes over, or there's still a lot of confusion. As much as we try and keep things straight, people are very confused between what's a personal directive, what's a guardianship order, what's a power of attorney. They mix up power of attorney and personal directives. So the capacity assessment aspect of this is so important, so that people we're not assuming that someone has or does not have capacity. There's ways for it to be determined, and it's not just an automatic thing, and not everybody can make that assessment.
Perfect. Thanks. Maya?
Yeah, I just wanted to echo Melanie's comments. I think learning about capacity assessment, one really important thing Melanie said was, I think a lot of people do shy away from the process of getting the proper documentation in place because of fear, which makes perfect sense. I mean, everybody wants to continue to do your own financial stuff. You make your own decisions. I mean, the idea of, especially as you age, of having decisions taken away from you can be really, really difficult even to contemplate. But I think the more we learn about mental capacity, well, it's important to know that, as Melanie said, the documents don't come into effect when you sign them. For the most part, you can create those documents as springing documents. And what that means is you'll sign them with a lawyer like me, but they don't come into effect until some future event has happened. And usually that future event is your loss of capacity. So I have a personal directive and a power of attorney myself. I signed them long ago. But they haven't come into effect. And so they'll spring into effect in the future, but they haven't taken away any of my rights or entitlements. So I think that's really important for the public to know. And another thing that Melanie mentioned that I just wanted to flesh out was the idea of a spectrum of capacity. And there's no bright line. I wish the courts would write a decision where they would sort of identify all of this as exactly what capacity is needed for what. But in the academic literature and what we discuss at law school is that, well, one person who's a wonderful writer on this, his name's John Posner, if any of you are interested in learning more about the legal academic side of capacity. But anyway, he did a discussion, and I really liked what he said, which was that he said there's no point when we lose mental capacity that like a turkey, I don't know what those things are, but you know, those things you stick into a turkey and when they're done, they pop out. He said there's nothing on a human where when you lose capacity, you can look at and like realize visually that that person has lost capacity. Capacity can be really fluid. All of us with elderly and aging people in our lives know that they have good days and they have bad days. And, you know, as somebody sort of slowly declines, it can always be a really hard assessment of when they reach this bright line of losing capacity and what that means. But another thing he spoke about, so this is his idea, not mine, but I agree with it, is a spectrum of capacity. And so the thought being that you need about 80% of your capacity to be able to handle your own financial affairs, and then maybe about 60 to 70% to do a will, and then maybe only 20 to 30% to do a power of attorney or personal directive. And then actually, interestingly, the thought in the academic literature is you maybe only need 10% to be able to marry. So legal decisions, and that's not, there's no, as I said, there's no legal decision. This isn't something that, this is just sort of, people are throwing around ideas of a spectrum of capacity. And I think the underlying idea is, the more complex the legal act, the more capacity is required for you to do it. So I'm sure there are people who thought, you know, I don't think I have a developmental disability, or I have something that would preclude me from being able to sign a will, or from being able to marry even. But the important thing I think for people to know is that capacity isn't a bright line. It's not that you're on one side of it or the other. And depending on what legal act you're undertaking, your capacity levels might be different. And so I meet with people who have, you know, mental disabilities and who have some cognitive issues. And often as a lawyer, I determine that they do understand the document they need to sign. But as the action becomes more complex, the level of capacity required to do it also changes. So I think that's just another thing to know about capacity.
Yes, thank you both for like you said, fleshing that out more. I think, you know, learning about it is so important because, as you said, there's so much to know about it, and it affects everyone, but it affects everyone differently too. And so for everyone to have an idea that, you know, you might fit somewhere along this spectrum, but like you said, nothing's going to pop out and say, you know, da, 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 you've lost your mental capacity kind of thing, right? That doesn't happen. Although in some cases it probably does, if there's, you know, if you're a significant medical event, but that's I would say probably much more rare than for most people. It's a, you know, progressive type idea or as you said, an ebb and flow. Okay, so thank you for sharing about that. And that kind of leads into our next question here about the misconceptions people have about mental capacity. We've talked about a few of them already in terms of, whether it's black and white versus on a spectrum, the effect of documents, that they don't come into effect right away, which is a big one. I've experienced dealing even with my own family members who, again, signing those documents thinking, oh, well, they're in effect now. And no, that's actually not the case. We want to ensure that someone is able to make decisions if they can for themselves, and empower them to do that, but have the fail safe for when they no longer can. So, but are there some other misconceptions, or perhaps we want to flesh out some of the other ones? I'll start with you, Maya.
Well, one thing I touched on that I wouldn't mind talking a little more about is the idea that you don't have to have perfect mental capacity to be able to sign a will. You don't have to have perfect mental capacity to sign a power of attorney or personal directive. And because those are simpler documents, you may even be able to have a lesser degree of capacity. But there was a recent case called the From Estate that came out a few years ago. Anybody who's interested can contact CPLEA, and I'll provide the case and the citation. But in any event, I think what was interesting from that case was they discussed the fact that you don't have to have, you can have issues mentally and still be able to execute a will. So I think that's a misconception, is people would think, well, I've got some degree of dementia, or I have some cognitive issue that concerns me, and so I don't want to do a will, I'll just leave it. But this is a quote from the court. They said, by the terms a sound and disposing mind and memory, it has not been understood that a testator must possess these qualities of the mind in the highest degree. Otherwise, very few could make testaments at all. Neither has it been understood that he must possess them in as great a degree as he may formally done, for this would disable most men in the decline of life. I don't know why this is all using male pronouns, so you just have to mentally add in the female to this. The mind may have been some degree debilitated, the memory may have been in some degree enfeebled, and yet there may be enough left clearly to discern and discreetly to judge of all those things and all those circumstances which enter into the nature of a rational, fair, and just testament. But if they have so far failed as that cannot be discerned and judged of, then he cannot be said to be of sound disposing mind and memory. So I think one misconception is, if you have any issues, you probably can't draft a will. And I just wanted to clear up that the courts have made it very clear that that you can draft a will even if you do have some mental capacity challenges. And as a lawyer, it would be my job to talk through and ascertain whether you understand the document. And then sometimes if there are issues, or if we fear that somebody may challenge a will, then we would often get an assessment from a medical professional. So a common way for us to sort of shore up our assessment of capacity is to ask a doctor or a capacity assessor, or somebody who has the ability to make that determination, to assist us with helping a client to sign a will if they wanted to. So I guess the misconception I want to correct is that you don't have to have perfect capacity to draft a will. And even if you have limited capacity, it's still worth a conversation with a professional.
Thanks. I feel like I need to do like a bit of a correction to our slide earlier when I was talking about the spectrum and having black and white when it comes to legal documents. I think you've highlighted that, it isn't maybe as black and white as we're making it out to be. But also, like you said, what is necessary changes as well. So you will need to have the capacity necessary for that document, which may not be the capacity necessary for another document. So thanks for clarifying that and highlighting that, Amaya. Much appreciated. Melanie?
So I have a few misconceptions actually to discuss. I think one of the biggest ones, though, is what Maya already said, and I see it all the time in the complaints where someone has gone and written a new personal directive, but family feels like they didn't have capacity to do that, and trying to explain that difference to them, that decision-making capacity is different than the ability to write a will or a personal directive or a power of attorney. So that's a huge huge misconception that's fairly rampant out there. One of the other ones is that, like we talked about, that your personal directive or your power of attorney takes effect as soon as it's written. It's unfortunate that some of the other provinces' legislation does work that way. BC's document says on it that it takes effect upon writing, so people get confused with that. A bit of a alarming trend that I'm seeing is people getting their personal directives and their documents done by lawyers, and lawyers are actually putting in the document that it takes effect upon writing. So Maya, maybe you and I can have a discussion about that later, because I'm not sure where to go with that now. It's very confusing, because then we have to turn around and tell people, no, that's not the way that it works. Another misconception is that capacity is all or nothing, and that loss of capacity is permanent. And there are many situations where a person can regain capacity, or like Maya said, that it's fluid, and sometimes a person with dementia will have a really good day and will be able to make decisions, and sometimes they won't. Or somebody that's maybe had a brain injury may have temporarily lost their capacity, and that it can possibly come back or improve later on. So that's a fairly common one as well. Checking my, another one that I think we'll probably forever be arguing with people is, that's okay, my husband has authority to do it. I don't need a personal directive, or I don't need a power of attorney. And, you know, when we do public presentations, there's very seldom a time where we don't hear that, where people think that your spouse automatically has that authority, or that when a person with a disability turns 18, their parents still are their legal guardians. And in this province, I would assume in all provinces, that's not true. When they turn 18, they become their own guardian until they've had somebody apply for guardianship, which can be done at 17 now and doesn't take effect until they turn 18. So I think those are the main misconceptions that we talk about. One, I guess, is that you have to have a lawyer do your personal directive and power of attorney. And even though you don't have to, our office, and I know most people encourage that people to do it through a lawyer. I find the documents are more often just better written, and everything's there together in one package. There's still a bit of confusion that, well, I have a will, so I don't need a personal directive or a power of attorney. So those kinds of things are still out there. But I think us working along with Alberta Health Services and the health regions, and along with the lawyers, we're all coming a little bit closer together with putting the same information out there.
Excellent. Thank you. Thank you both. And those are, you've highlighted some misconceptions that we hear come through CPLEA's, interim referral line as well, but also just, my own personal experience. And I think the other one that I would highlight, if I may, just from conversations with friends and family, is that often people think that mental capacity is an older or an aging person issue, and it's not. I mean, I remember once I was at a presentation and someone was talking about, I think it was a lawyer, and they were mentioning, that a 30-year-old gets riding their bike, gets hit by a car, and is suddenly in, a medical coma or has a severe medical condition, and they don't have the documents in place. And that is, that can happen to anyone. And so it's not just an issue of, as you get older, it's something that can affect anyone. And as Maya said, I mean, she herself has the documents, drafted. I have my own drafted as well, for that very reason of that we never know. And I think it's something that when people turn 18, they should just, get a will, a personal directive, and a power of attorney, so that
I think it should be part of a school program where they
I agree.
talk about it. Yeah.
There's like a becoming an adult package, and like that's part of it.
Jess, you just reminded me of one more, if you don't mind.
Absolutely. There's
also that misconception that as soon as somebody turns elderly or turns a certain age, then they automatically need a decision maker. And a lot of long-term, not a lot, but some long-term care facilities will insist that a person has a personal directive or a guardian, some kind of legal decision maker in place before they're admitted to the facilities, which they're not allowed to do. So it's it's an uphill battle sometimes because it's so not fair. My grandmother was 93 when she passed away, and I was her agent on her personal directive, and we never activated it until 2 days before she passed because she was in a coma. Otherwise, she was perfectly capable of making her own decisions. So I think that's a really unfortunate misconception.
Excellent. Thanks for highlighting that as well. Actually, Melanie, I'm going to go back to one thing you said there. You mentioned that care homes will often ask for it. Now, are they asking for it to just have a power of attorney or a personal directive in place, or to actually have it activated?
It depends on the facility. I've seen both. I guess the biggest one is if they don't have a personal directive, then we want them to have a court-ordered guardian before we'll allow them to come in to the facility. So, I mean, the Personal Directive Act says that they can't demand a personal directive because it's a voluntary document to make. Absolutely, we encourage it, but you can't force somebody to have that, nor do they always need it just because they're elderly and going into a care home. If it's a secure facility, that might be a little bit different, and there's work being done on that to try and flesh out what's needed and what they'll need to be able to come into a facility like that. Does that answer that good enough?
Yeah, just clarifying. So people, we obviously encourage everyone to have it regardless of what age they're at, but that a continuing care facility cannot demand that someone have it or even demand that it be activated.
Right.
Okay, perfect. Thank you for clarifying. Okay, let's move on to our next question here. This one's from Maya. When and how do lawyers assess mental capacity? You've talked about it a little bit. Is there more that you kind of just wanted to summarize or highlight there?
Sure, yeah. So when we're talking about lawyers in this area, usually we're talking about estate planning lawyers. And the question of when we assess capacity, actually, it's an interesting question because we're tasked to do it twice. We usually take a gauge of a client's capacity, both when we meet them to take instructions, and then again when we do a signing. So it's useful to meet with clients twice for that reason. And sometimes clients are irritated that they have to do 2 meetings with me. But it gives me a good, because these are people I don't know and I'm meeting often for the first time. If I'm meeting them twice, it gives me a good sense of the variation of their capacity. So sometimes you can meet somebody on a really good day and that could be their signing day, but the day that they gave me their instructions, they were having an off day, or maybe the answers that they gave me 2 weeks prior, I can gauge them against the answers they give me when they sign. So if you meet with a lawyer and the lawyer is asking you questions about what assets you have, who are your family members. Often I'll do that in the intake meeting, and I also do it again in the signing. And sometimes, again, clients get irritated because they're like, "Oh, I've told you I have those TD bank accounts." But often it's just a way for me to make an assessment. There is some interesting legal what am I trying to say? There's some legal concepts that have come out in the cases recently in Alberta, talking about how challenging it can be for a drafting lawyer to assess capacity, because the truth is, somebody could come in and tell me they have TD bank accounts and a house insured park and a car, and I don't know this person. So it may be that that's true. It usually is. It also could be a complete delusion. And so I only can really do what I can do from my own meeting and my own assessment of people. So taking capacity gauges twice sort of helps me to see whether or not they are in fact able to do it. The other way we do that sometimes is to have another family member in the meeting with us. And if I notice the family member is correcting them regularly, like, "Oh no, that's not your granddaughter's name," or "No, you don't have that CIBC account anymore," that can also give me a little bit of a sense of some limitations on capacity. But there are quite a few cases now in Alberta where lawyers are basically completely blindsided by capacity, because somebody can actually, and I know Melanie has dealt with this, I'm sure, quite often, somebody can come across very cogently, very compellingly. My own grandmother had dementia, and there would be days when she was talking complete nonsense, but she really put herself together to be able to say the things that she was saying. So she looked very, very like she had a very good capacity. She was saying things that sounded really real, but they weren't. And so And often, sometimes when you're assessing capacity, that's when people kind of rise to the challenge. I'm sure Melanie's seen that too. So although sometimes they can be really having challenges with capacity, when you assess them, actually that day they'll be excellent. And so sometimes we knew there were, you know, challenges with my grandmother, but on days when she was being assessed, she came across great. So all of which is to say, it can be really challenging for a lawyer to be able to glean capacity from the limited number of meetings that we have with clients. And that's why we aren't considered true capacity assessors in the legal sense. We don't do, you know, the types of tests that capacity assessors do. What we do essentially is we look for the testamentary capacity test. And so that comes from an old case from 1870, actually. Not all of the cases lawyers use are from like old timey England, but that is one that we still teach in law school, and it's still the leading case in Alberta. And the case is, I'll read it to you because it is an old timey English case. But it's essential to the exercise of such a power that a testator shall understand the nature of the act and its effects, shall understand the extent of property of which he is disposing, again, a lot of male pronouns, shall be able to comprehend and appreciate the claims to which he ought to give effect, and with a view to the latter object, that no disorder of the mind shall poison his affections, pervert his sense of right, or prevent the exercise of his natural faculties, that no insane delusion shall influence his will in disposing of his property, and bring about a disposal of it which, if the mind had been sound, would not have been made. So that's the technical legal test. It's again from the case of Banks and Goodfellow, 1870 English case. And so that's what lawyers are trying to assess. We're trying to assess, and in layman's terms, in Canadian terms nowadays, we're trying to figure out what is the nature and extent of their property. Do they know what they have? The persons to who are the natural objects of their bounty, that's their family members. Do they understand what they're asking? Do they understand the testamentary provisions that they're making? And then they have to sort of appreciate the factors in relation to each other and form an orderly desire. So it doesn't mean you're able to tell me everything about your life. It doesn't mean that you can't make an unusual disposition. Like sometimes clients come in and say, yes, I have children. Yes, you know, I love them, but I want to give everything to the SPCA. That doesn't mean somebody's insane. And I can't insert my moral judgment about whether or not I think that's the right or the wrong call. As long as they can explain to me, you know, my kids are well off, they don't need the help. Whereas I've sort of, like Melanie, committed my life to animals. And so that's my priority at this point. So, so when lawyers are assessing capacity, that's the test that we use, is the Banks and Goodfellow test. And when we're asking questions of clients, if you're being faced with those questions, those are the types of things we're interested in. So if you're marshaling a family member to meet with a lawyer, sometimes going over those types of things can be really helpful, not to coach them or to refresh their memory, but to sort of prime them on the idea that the lawyer is going to be asking sort of quite intrusive questions about who owns title to the house, and who's a designated beneficiary in your TFSA, and are your grandchildren disabled, and is that person a boyfriend, or who are they? So those types of things can be able to make those assessments. So that's how lawyers assess testamentary capacity. We try to do our best. Like I said, if I have any inkling that there might be a capacity issue, sometimes it's raised by the family who's bringing their family member in. Sometimes it's something that I'm ascertaining in the meeting itself. I will enlist a medical professional to help me. And sometimes I say that to the family. I'll say, you know, I'm not saying you don't have capacity, but I'm concerned, given these factors, that, you know, somebody else may suggest you don't have capacity. So I think we need to insert another professional here to kind of shore up my opinion. And that's a very common challenge. We teach it in law school as the most common challenge to an estate is capacity. So if you have a family member who has some kind of mental challenge, be it a developmental disability or Alzheimer's or dementia or something that is clouding their judgment, or disorders of the mind, or delusions, which are an interesting new frontier of mental capacity. If you have any of those types of things, we sort of need to do a little bit of extra due diligence to make sure that the will is protected, which kind of goes back to something that Jess and Melanie mentioned, which is having a lawyer, you don't have to have a lawyer to do any of these documents, but if there is a question mark around mental capacity, or if you feel like a family member may challenge capacity, having a lawyer really helps, because as part of my obligations, I assess capacity, I document it in my file, and that can really help if later on the will is challenged or capacity is challenged. If I'm litigating a file and I find out that a lawyer did the will, I'm much more, I guess, concerned that the will is going to stand up if I'm one of the people challenging it, because a lawyer is going to do a lot more due diligence than a will, for example, that's done, in the back of a car by a whole bunch of people who aren't lawyers. I think there's a lot more concern about what happened in that transaction than there would be if it's done in a law office. So that's one of the protective elements, which isn't to say you have to use a lawyer. It's just that if capacity is in play, I think using a lawyer can be a really good idea. So that's any questions on that, I'm happy to answer.
Thanks, Maya. We'll move here now. I promised, as we kind of talked about the distinction earlier of Maya's role in capacity assessment, and now we'll look at capacity assessors and Melanie's role in her work with the Office of the Public Guardian.
Okay, so under the Adult Guardianship and Trusteeship Act, only certain professions can conduct decision-making capacity assessments. Physicians and psychologists were grandfathered into the regulations, so they can do them automatically without specific training. We did discover, though, once we implemented this legislation, that physicians and psychologists weren't very comfortable doing that without any training. So we did develop some 2-day workshops for them. They're not mandatory, but definitely recommended, and there's been a lot of uptake on those. The other 4 professions that are actually named in the legislation are registered social workers, registered occupational therapists, registered nurses, and registered psychiatric nurses. Those are the only 4 professions that can take the training. They have to take the 3-day workshop and pass an exam at the end of that workshop, and they have to then be designated by the Minister of Justice, or whatever ministry we happen to be in, but right now we're Ministry of Justice and Solicitor General. And we're now in the Strategy, Support, and Integrated Initiatives Division instead of whatever division we were in before, but they do have to be designated, and until they receive that designation, they cannot conduct capacity assessments. And this is under the AGTA only, the Adult Guardianship and Trusteeship Act. And every 2 years, they have to do a review of their competency to continue to do capacity assessments. So that's my job, is to maintain that roster and keep all of the capacity assessors on a list and make sure that they do their continuing competency. We do have lots of questions about why other professionals can't do them. It would just be too hard to monitor if we had too many different groups. And to keep it consistent, these are the groups across other provinces that can also do capacity assessments. So it does keep that consistency. And we just felt like they were the groups that were the most qualified to be able to do, which doesn't mean other professions don't have that ability, but these are the 4 that we thought were the most important to have those designations. So I provide the workshops generally once a year. Right now, with it being online, we're doing more just to try and get as many people trained as we can. The 3-day workshops are in huge demand. I just did a 3-day one in November for 40 people, and I had closer to 90 applications for that one course. So it's very definitely in demand to have it done. I think that was all I wanted to say about what capacity assessors are. We do not, I noticed there was a question about the MAID Act, Medical Assistance in Dying. We do not have any authority in that legislation, so we don't have any training or any information about being able to do those assessments. Under the Personal Directives Act, there's a couple of different assessments that can be done depending on how the personal directive is written. If the person names somebody to determine their capacity, then that person does part 1 of a Schedule 2, and a physician or psychologist has to do part 2 of that form. If they don't name anybody, then it's a Schedule 3 that's used. And I know there's a lot of different forms and stuff, and I don't want to confuse people, but If it's on a Schedule 3, a physician or psychologist has to do Part 1, and a second service provider does Part 2, which could be a nurse or the director of a facility or anybody whose intention is to provide that person with, I believe it says medical services or health-related services in the Act.
Perfect. Thank you, Melanie. So yeah,
welcome.
we've seen how the role that lawyers play, but then we have these formal capacity assessors as well, which Maya said even, lawyers can sometimes defer to as well to shore up their own assessments. And you'll see the term like the capacity assessment, which can be a formal document. And we're going to talk a little bit more about capacity assessments in some of the other webinars, because they do come into play in other types of decision-making tools. We see sometimes where they're actually necessary to get. So that's Melanie's role, is training them all. And as you said, so just to be clear, not all registered nurses or whatnot, or occupational therapists can do it. It's only the ones that get the specific training and are designated and accredited to do it. So
yes, that's right.
Perfect. Okay. Just so there's no confusion. Everyone's going to their nurse saying, okay, I need an assessment. But that they're, that is their specific training for that.
Right.
I see we're running close on time here, so I'm going to really quickly buzz through the last question, and that's really resources available for people wanting to learn more about it. Melanie, I think you had a couple that you wanted to highlight.
I was just going to say the OPGT website has lots of resources for capacity assessors, but Alberta Health Services and Covenant Health also on their websites. We work a lot with those groups, and they've developed some really good educational programs and some workshops that you can attend. So their websites are also really good.
Perfect. And Maya, anything to highlight?
Well, I've been calling it CPLEA, but now I'm learning it's CPLEA. They have some really good resources. So if you're here, you probably are already aware of them, but good to know. And lawyers, obviously, if I wouldn't assume that somebody is incapable of doing something. It's often worth a discussion with a lawyer to talk about mental capacity. So feel free to meet with a lawyer who probably specializes in estate and estate planning. I think lots of lawyers probably specialize in that area across the province. So that would be my suggestion, is to go with somebody who does this as at least a majority part of their practice, because it can be a little challenging. And then there is, if you want some pro bono legal advice, we have what's called the Edmonton Community Legal Center, ECLC. It's a wonderful organization here in Edmonton that gives free legal advice to people within, I think, a certain income bracket, but they're wonderful, and I volunteer with them. They do provide wills and estates advice to people as well. And I can see that the link is being sent out to everybody in the chat. So ECLC is another area for resources.
And thanks for highlighting that. And I will highlight as well, ECLC is in Edmonton only. There's another organization in Calgary, the Calgary Legal Guidance. There's a clinic in Grand Prairie, Lethbridge, Medicine Hat, Fort McMurray, Red Deer, and I'm probably forgetting one, but we can post a link in our chat, or Natalie already has the legal clinics across Alberta. You can click on that and find, there's a whole list of them across the province. So thank you both for highlighting that. I am, as Maya mentioned, we do have some resources here at CPLEA. I'm going to highlight quickly two of them. We have an info sheet on mental capacity, which talks about, the definition we provided today, the spectrum. So kind of highlights the pieces that we talked about at the beginning. And then we also have a document called Planning for Incapacity that talks about the different types of decision-making and some of the different tools available, which of course we'll work through in the next few webinars. Those are all available on our website, cplea.ca. And if you click on the planning for the future, legal info, the planning for the future little button there, it'll take you to all of that. We have many, many more, which we'll highlight throughout the rest of the webinar series on this topic, but those are the two I wanted to bring to your attention today. We are not going to be circulating our slides today because we just had a few at the beginning, and the information in those slides is found in these two documents here. And then of course our conversation is being recorded so that you can access it on demand going forward if there was an important piece that you wanted to go back and check out. Natalie is posting the links to those resources in our chat as well, so watch for them there. And when we send out a follow-up email, we'll make sure we highlight them. Okay, we have one more minute, couple minutes. Melanie or Maya, do you have an extra couple minutes to stay on to answer some of the questions? I see there's 2 in the chat box here. So I'll start with, does the Office of the Public Guardian support or provide resources for assisting with considerations that are made? Oh, Melanie already answered that, and the answer was no. They do not deal with that. So then the second one, in hospital, I've seen a few documents stating that PD takes effect upon signing. Are you saying this is not valid?
I'll take a shot at this, and then Melanie can supplement, because I think she sees this maybe more than I do. But I just brought up the Personal Directives Act, and Section 9 of it says that a personal directive or part of it has effect with respect to a personal matter only when the maker lacks capacity with respect to that matter. So the Personal Directives Act is pretty clear that in order for it to come into effect, the person needs to lose capacity for it to be brought into effect. So our firm's practice has always been that our personal directives only come into effect upon incapacity. We don't have any that are immediate in nature coming out of our firm. Partly that's just a practical consideration, because it doesn't make sense to have delegated away one's personal decision-making when one can still do it. And as I understand from the medical community, you'd probably rather it come from the person for whom the treatment is being considered rather than a third party. So we've always made our personal directives springing. We don't do immediate ones. And as I read Section 9(1) of the Personal Directives Act, I think it requires a lack of capacity on that issue before it can come into effect.
Yeah, I agree with that as well. Some of the directives that come from other provinces, they can be valid in Alberta, provided they don't contravene any of our laws. So the BC one that says it's immediately in effect, they still have to have a capacity assessment here to say that they can use that document, but they have to have a capacity assessment that says that they no longer have capacity.
And just as a small point, you actually can have an immediate power of attorney. So that can be a little confusing. My view is personal directives in Alberta come into effect upon incapacity, and you can't make them immediate. But confusingly, enduring powers of attorney can either be immediate or springing. So it's very common for people to say, I have full capacity, but I want to delegate my financial stuff to so-and-so. And that's perfectly valid. So you can have an immediate power of attorney, but immediate personal directives based in Alberta should not be generally done. That's my view.
Perfect. I'm going to just go through the chat quickly. I see there's a couple questions that got posted in there. So I have one about, to be the second service provider for a Schedule 3, can it be professionals other than those who can be designated capacity assessors? For example, an LPN.
Yes.
Okay, perfect. Melanie covered that one. I'm just going to check. I thought I saw this here. Someone had posted a scenario, and I'll just encourage that person at this time to maybe reach out to the Office of the Public Guardian or someone to get some more support on that. We're not able to provide any type of legal advice during this session, so I just encourage that person to reach out further. Natalie, who's one of the faces behind the black boxes on your screen, one of our colleagues here at CPLEA, has posted a link to a chat. So we love your feedback on today's webinar. So please take a moment to do that if you can. But I think we're going to wrap it up there. Oh, I see. What about specific decision making? I'm going to just cut that. I'm going to say we're actually going to talk about that in the 4th webinar. So in the interest of time, I'm going to say tune in on March 2nd, and we'll be covering that one then. And reestablishing capacity, is it the same assessment process, Melanie?
Yes, it's just different forms, but it's called Declaration of Regained Capacity. Perfect. Under the Personal Directives Act, not under the AGTA. They would have to have another full capacity assessment to see if they have capacity.
So it depends on what you're getting capacity for, if it's under a personal directive or if it's a tool under the AGTA.
Right.
Okay, so hopefully that clarifies it for that person. So we're a little bit over. I'm going to wrap it up there. I know our presenters have other things they need to be getting to. So I want to say a great big thank you to Melanie and Maya for joining us this morning, for sharing all of your knowledge and expertise with us. And yeah, so thank you very much. And we'll wrap it up there. Like I said, please fill out the evaluation. And we'll see you on, oops, I didn't even get to this slide. I got so excited about wrapping it up. So our next session is making a will on February 2nd, same time, 10 a.m. And then we will be talking about personal directives and powers of attorney on February 16th and the Adult Guardianship and Trusteeship Act on March 2nd. You have to register for each one separately. So those, the registration links are at cplea.ca/workshops. You'll find all of them there. So we'll hope that you'll join us for the next three, sorry. But we'll leave it there. Happy Wednesday, everyone, and have a great rest of your day.